Well, welcome to Facebook Live. Appreciate those of you that have tuned in again today. We've been doing these Facebook Live episodes now COVID's been around now for 4 or 5 months, and we've been doing them every Wednesday at 1 o'clock p.m. So thank you for joining us today. My name's Brad Bodis, and I'm an attorney with the Bond and Bodis Law Offices. We are located throughout Alabama, throughout Mississippi, and we're in the Knoxville area in Tennessee. And we help people with money problems, and we know a lot of folks out there are having money problems right now. So we've started doing these Facebook Live episodes every Wednesday at 1 o'clock p.m. just to discuss topics that are of interest to people concerning finances, concerning bankruptcy, and concerning important decisions that people are making right now. I'm fortunate this week to have as a guest my friend and fellow board certified attorney, Reed Allman. Reed runs one of the largest consumer bankruptcy firms in Texas. He has offices in Dallas and Fort Worth. Reed, welcome.
Thank you for having me.
Appreciate you being here today. For some of our viewers that aren't familiar with you here in the Southeast, tell us a little bit about yourself.
All right. Well, I started doing bankruptcy about 20 years ago. I grew up in Texas. I've always lived here. Originally, when I was younger, I lived in Abilene, which is kind of central in Texas. It's called West Texas, even though it's kind of in the middle. But I went to school there, went to Abilene Christian to get my undergraduate in accounting and finance, and then went straight into law school. And I knew I wanted to do something with my legal career that was going to give back to people, that was going to somehow be a service, a service kind of mission, but I didn't know what that meant. So I really feel like I've been extremely blessed, and God has guided me into bankruptcy to build a career. And I've had some great mentors and just a wonderful opportunity to really to help people, good people that are just going through some bad times, deal with their finances.
Wow, that's a great approach. I feel the same way. I often feel that what I'm doing is almost a form of ministry. People come and they're really hurting with financial problems, and it's great to be able to help them. It's also great to hear that, unlike a lot of attorneys, you have an undergraduate degree that helped with your practice. You weren't a history, political science major like a lot of attorneys.
No, I did like history, but I did go the practical route.
Well, I'm sure that helps a lot with what you're doing today, helping people with money problems. Reed, you said you grew up in Texas, and Texas is similar, I am sure, to where our offices are located. We're in Alabama, we're in Mississippi, we're in Tennessee, and firearms are more than just an item of property. They're something special to people. People grow up hunting with their parents, with fathers, with grandfathers. Sometimes firearms are passed down from generation to generation, and they have significant sentimental value. So what I want to do today, and the topic today, is to talk about how firearms are treated in bankruptcy. And importantly, am I going to lose my guns? Is somebody going to take my guns if I file bankruptcy? And I know that this is a topic that's very important to you. I know that you've addressed it on numerous occasions. So we have some questions put together. But before we do that, why don't you just kind of give us a general overview? So if somebody comes to see you, Reed, and you've counseled with them, you've made the tough decision that things are at a point where you're going to need to seek some sort of bankruptcy protection. How do you factor in guns that they own and how they're going to be able to protect those guns? What are the factors that come into play?
Sure. In that the number one question, a lot of people fear filing for bankruptcy. They think they're going to lose all their property, and that fear can often lead to some poor judgment on some pre-bankruptcy planning. So we have a questionnaire. We ask everybody to tell us all different kinds of property they own, including firearms. And so we want to get an itemized list of exactly what type of firearms they own and how much the value is associated with those, so that we can match them up with exemptions, which are basically a legal term under state and federal law that says if you file bankruptcy, you're able to keep certain property. And so all the property is broken up into different exemptions that allow people to file the bankruptcy, wipe out their debt, but still not lose everything that they own.
You know, you made an important point. You said people, because they're worried, in bankruptcy, financial issues are emotional. And by the time people come to see you or come to see one of us, that they've tried every other option. You know, talking to a bankruptcy attorney is the last thing they want to do. But often people wait too long and they make decisions that aren't wise. And I want to emphasize for potential clients in the Dallas-Fort Worth area, for people that are having money issues in Alabama and Mississippi and Tennessee, talk to a bankruptcy attorney early before you make any poor decisions. Don't try to transfer property to keep it out of your bankruptcy. Don't do things that could really hurt. The opportunity Reed might be able to have to help you, or one of our attorneys. We want to help you all we can. Reed, I imagine your firm, like ours, with COVID, we're offering initial consultations. In fact, all of our consultations are by phone or video right now. Are yours the same there in Texas?
We do have our office locations open if somebody feels more comfortable coming in, but even if they come into the office, we put them in a consult room where they're in there by themselves and they're video conferencing with somebody else in the office, so they're not face to face. But yeah, luckily we had invested in a client portal that people can access through our website. And so it has the feature to have video conferencing, secure video conferencing, and secure document upload. And so it's been really wonderful for us. We've been doing probably 30 to 50 meetings a day virtually with clients, and it's been going wonderful.
Now, the fact that I want to emphasize, and Reed, I checked your firm's website, so I'm not speaking out of line here, but Reed's firm and the Bond and Botus Law offices are offering free initial consultations. You can reach out and talk with an attorney and get some guidance without leaving the comfort and safety of your home or office. We can do it by video. As Reed said, if you want to come into an office, we can make that work. But it's a safe process, and there's no reason not to reach out and get advice if you're having money problems. Reed, I'm sure you're the same. Just because somebody calls me, it doesn't mean that they need to file bankruptcy. We explore all options and rule out other options before we even talk about bankruptcy. So folks, be proactive. A lot of us are having money problems. I can tell you, and I'm sure Reed's the same from having done this for many, many years, good people have money problems. And a lot of good people are having money problems right now.
Yeah. You know, it's you're totally. I mean, we could probably swap horror stories of people that have made decisions out of fear and worry because they think they file bankruptcy, they're going to lose everything. People still think that, and they'd be surprised at how generous, at least in Texas, how generous the exemptions are and how much people, most people, 99.9% of everybody I see, 100% of their property is exempt, and they'd be able to keep everything after the bankruptcy. So yeah, I mean, we call our consult a financial empowerment session, where we're going to focus on really getting the specifics of their case, presenting them all the different options that are available to them, so then they can make smart legal decisions. And 40% of the people we see, for whatever reason, may not be a good candidate for bankruptcy, but hopefully they walk out of there knowing more about their finances than they did when they walked in initially. Well, I think we lost Brad. So if you're still with us, hang on. Looks like he's logging back in. So we're we're here, like Brad said, we're from the Dallas-Fort Worth area, but we're also doing bankruptcy cases across the state of Texas. So if you're interested in that, please let us know. We'd be happy to talk with you. So the topic today is on guns and bankruptcy. And so what happens if you're worried about that and you're worried about losing your property when you file for bankruptcy? Some of the questions that we were going to go over was going to cover things like, do I have to declare my guns when I file for bankruptcy? And the answer to that is yes. When you file for bankruptcy, there's an obligation that you have to provide all of your assets. So let's see here. And so what we do is we list those on your bankruptcy schedules. So there's a Schedule A for real property and a Schedule B for personal property. And so what we do is we list all the types of possessions that you can own, and then we have to match them up with a bankruptcy exemption, either under federal law or under state law. And so in Texas, we have the option to choose which set of property exemptions you want to choose. So some people will select Texas because it may have more favorable terms than federal law. So I know that that's kind of confusing. A lot of people don't understand, but we're lucky that some states will require you to just use the state exemptions or just use the federal exemptions. So in Texas, our most famous exemption is the homestead exemption. And so in Texas, what that means is that you're able to file a bankruptcy case and exempt an unlimited amount of equity in your house. So if it's paid for, that means even if you file bankruptcy, you're going to be able to keep it, even if you have $1 million or $2 million of equity in the property. Now, hey, Brad, you back with us?
Read.
Yeah.
Sounds like I appreciate.
Yeah.
Sorry,
yeah,
Wi-Fi outage here.
Oh, I'm sorry about that. Yeah, I just got started trying to answer the first question about declaring your firearms on your bankruptcy schedules.
Well, thank you. And again, I apologize to our viewers. We apparently had a Wi-Fi outage here, and I've logged back in through a hotspot on my cell phone.
Stuff happens.
Again, just for our viewers, I apologize for the interruption. We're talking with my friend Reed Allman with Allman Law out of the Dallas-Fort Worth area about the very important topic of protecting firearms in bankruptcy. And Reed was nice enough to take over for me there for a second. So you were on the first question we had here, which was, do I have to declare all of my firearms as assets? Do you have to list all of them when you file bankruptcy?
You sure do. You have to list all your firearms and all your other property. And so I was just diving into that topic and going about how to match up which set of property exemptions you're going to use, state or federal.
Well, in Alabama, Tennessee, and Mississippi, we've all opted out of the federal bankruptcy exemptions. I don't want to get too deep in the weeds here for our non-bankruptcy attorneys, but each state determines what property you can keep. But Reed, and I'm sure you're the same. Folks, if you're going to file bankruptcy, don't try to omit any of your assets. You want to disclose everything. You want to be honest. Financial problems are one thing. Criminal problems, which could result in trying to hide or conceal assets, are even much more significant. So what's your process? How do you said you went through an initial type questionnaire, but once somebody has hired you to file a bankruptcy, how do you gather an inventory of all of their assets, Reed?
Okay. Well, it's kind of a combination of just verbal questions we ask and we fill out, and also through our portal, we have a questionnaire that they fill out online. Just some probing questions to uncover different types of property they may own, and then we develop that with them, have a dialogue with them, see how we can make sure that they're thinking of everything. It'd be difficult. I can imagine, like, if I filed for bankruptcy, it's kind of difficult to think about all the spider web of maybe accounts or different things that you have. So we kind of help them through that process and ferret out those assets and put a good value on them.
Yeah, and that can be kind of an overwhelming process for individuals, listing what they own and assigning values. The term we always use here in Alabama is you want to use garage sale value for your assets, not what you paid for it when you first bought it. But if you had to sell it today, if it had to be liquidated, what it's worth. And as Reed said earlier in our conversation, in 99+% of our cases, we're able to protect all of an individual's assets through one form or another of bankruptcy. I've been doing this for over 30 years, Reed, and I could count on one hand the number of times somebody lost an asset unexpectedly. And when I say an asset, I mean their home, I mean their furniture, their jewelry, or more specifically here, guns that they own. And people sometimes will attach a value that's more of a sentimental value as opposed to what something is really worth. Another question we get, I'm sure you get, do I have to list a gun if it was a gift? Somebody gave it to me. I didn't buy it. Do I still have to list it in my bankruptcy schedules?
Yes, it's still considered your property, and so we still have to list it, disclose it. I mean, the idea is to disclose. I mean, if you tell your attorney everything, then we're in control. We know what's going to happen if you file the bankruptcy case, so we can tell you it's going to be protected, or we can even do strategic planning. So the key is really to disclose everything and list everything, and that way you know you're not going to have any problems.
Yeah, you don't want to surprise your attorney. After a bankruptcy is filed, the first thing that happens is you meet with a bankruptcy trustee. And it's very important, people, if you seek bankruptcy protection, that you've disclosed everything to your attorney. As the trustee is often going to find out about things. I've had trustees that go to Facebook pages. I've had trustees that look in classified listings to see that an individual may have had a garage sale leading up to bankruptcy, and there are records out there. So as Reed says, it's very important. Be as forthright as you can with your attorney so that your attorney can give you good advice, and so that you don't get into trouble later. But as Reed said, if a gun is gifted to you, it's still something you own, and it's still something you have to list. Right. That there are other follow-up questions your attorney may ask you, like, was it really just gifted to you, or was it gifted to you and another family member? Was it gifted to you and your spouse? Those follow-up questions may, impact the actual value to you of that firearm or your other assets. So I want to talk specifically about the states in which we practice, Reed, and the exemptions or what you can protect with respect to firearms. I'll start with the states in which I practice, then I'll let you speak to Texas law. So as I mentioned earlier, in Alabama, Mississippi, and Tennessee, each state has their own exemptions. Although bankruptcy is a federal law, the Bankruptcy Code provides that the individual states can determine how much property you can keep when you file bankruptcy. And Reed and I interact with other bankruptcy attorneys from across the country, and we know the exemptions from state to state can be extremely different, and thus the impact of bankruptcy and how bankruptcy is approached is different. In Alabama, you are allowed to protect a total of $7,750 in personal property. Now, personal means anything other than your home, anything other than real estate. If husband and wife are filing together, that's doubled. So it's just over $15,000. It's $15,500. That may not seem like a lot, but again, I remind people we're talking garage sale value here. You may have a couch or a love seat that you paid $1,500, $2,000 for a few years ago, but if you got children, if you have pets, good chance that couch has been walked on or upchucked on or things that have affected its value. And most used personal property just doesn't have much resale value, which is why, as Reed said earlier, we're able to protect so much for individuals. So Alabama, the total personal property exemption, including your firearms, is going to be $7,750 for each debtor. Mississippi and Tennessee are the same. It's $10,000 for each person filing bankruptcy, so $20,000 for a married couple. Reed, I'll add that Mississippi does have a specific firearm exemption. The code in Mississippi says that you can protect one firearm, but that comes under that umbrella, that $10,000 umbrella. We're able to protect most of your assets, and if your assets exceed the amounts that you can exempt, there are other options in bankruptcy. Tell us about the exemptions pertaining to firearms in Texas.
Well, I'm biased, but I think what you've clearly demonstrated is what they say is that everything's bigger in Texas and better, I would say. So our state exemptions allow you to exempt 2 firearms, and there's not really a limit on the value of those 2 firearms other than the total amount of personal property that you can have. And so if you're an individual filing for bankruptcy, you can have up to $30,000 in personal property. And if you're a family that's filing jointly, then you can have up to $60,000. I've even exempted an airplane for somebody who was a DBA, filed it, and they got to keep their airplane. So you're in good shape with Texas. And then also we have the option to use federal exemptions as well. So we can, any unused portion of the homestead exemption under federal law, we can also use as a wild card to exempt, if somebody had more than 2 guns, for example. So we have a lot of options.
Yeah, it's amazing how the exemptions vary from state to state. As I think you know, back when the current bankruptcy laws went into effect back in 2005, I was on the board of directors of the National Association of Consumer Bankruptcy Attorneys, and we really lobbied for more uniform exemptions. At that point, just as an example, and this is an easy way for me to explain how exemptions vary to non-attorneys. At that point, my firm had offices in Mobile, Alabama, Biloxi, Mississippi, and Pensacola, Florida, all as the crow flies with 100, 125 miles of one another. Somebody I was advising in Mobile, Alabama at that point, now the exemptions have increased slightly in Alabama, but at that point could only protect $5,000 of equity in their home. That was in Mobile, Alabama. If you went a little bit to the west in Biloxi, Mississippi, that person could protect $75,000 of equity in their home. If you went less than 100 miles the other direction, east to Pensacola, Florida, Florida's similar to Texas. Your homestead exemption is unlimited, so you could have a multi-million-dollar home and protect it in bankruptcy. So the exemptions vary quite a bit from state to state, which is one reason, and this is important for viewers to understand, which is one reason here in the Southeast, Chapter 13 bankruptcy, which is a personal reorganization type bankruptcy, is very popular. I want people to know that if your assets exceed the amount that you can protect, you can still protect them in a reorganization type bankruptcy in many cases by paying a percentage of what you owe to your creditors. So there are options, but again, it's so important when you meet with Reed or one of his attorneys, or when you meet with one of the attorneys here at the Bond and Bodas Law Offices, disclose everything so that we can advise you accordingly. I want to take a quick break here for anyone that may have come in midstream, like I did a little bit here when my internet connection went out. I'm Brad Bodas with the Bond and Bodas Law Offices. My guest is Reed Allman with Allman Law out of the Dallas-Fort Worth area in Texas, one of the largest consumer bankruptcy practices in Texas. This is Facebook Live, and we are talking about protecting guns, protecting firearms if you need to seek bankruptcy protection. I do want to emphasize that at both the Reed's firm, at Almond Law, and at the Bond & Bodas law offices, we are offering absolutely free initial consultations with an experienced, licensed attorney. Reed and I are both board certified. We take what we do very seriously, and we encourage you, if you're one of the many people having money problems right now, reach out and get advice before it's too late, before you're facing a potential garnishment or repossession or foreclosure. The anxiety of dealing with debt can be just extremely tough. It can have impact on your own mental health, on your marriage, on your family. So reach out for help. We want to give you good advice before the trouble really starts up. Reed, next question I had here, can I transfer ownership of my guns to a family member so that they don't go into my bankruptcy?
Well, that's kind of a loaded question. I mean, technically you could transfer to a family member if they pay fair market value and you use the funds before filing bankruptcy for necessities. But the way you phrase that question makes me think that the intention for transferring it is to hinder or delay the creditors from being able to get the non-exempt property. And so that would fall into the category of fraud. And so when you file the bankruptcy case, you're required to disclose transfers of property, at least within the last 2 years, and sometimes longer for other types of transfers. And then you'd have to explain to the bankruptcy trustee what you transferred. And the trustee has the power potentially to avoid that transfer and get the property back from the family member and sell it. Which in most cases, if they would just have waited, talked to you about it, you could have exempted it, filed the bankruptcy case, and there'd be no issue. So I would strongly advise people not to transfer property if you're considering bankruptcy, especially the insiders. You should consult with an attorney so they can guide you through that process and navigate what is an advisable transfer and what isn't.
And just to clarify for viewers, insiders is a legal term, but in this instance, we're really talking about friends, family members. It could be a business associate, but it can be very dangerous trying to conceal transfers of property. Another reason why you need to reach out and talk to a bankruptcy attorney early on, before you get too deep into debt, and while still options may be available. And even more importantly, Reed, and I'm sure it's the same way in Texas, when people start having financial problems, something's going on like currently is in the economy. Although bankruptcy filings are still down as opposed to last year, most people expect bankruptcy filings to go up in the near future. And when that happens, a lot of new people will get into the practice of bankruptcy law. And they may or may not give you good advice, but I would encourage you to reach out to somebody that has experience and that has been doing this type of work for a long time. Just because of the type issues Reed and I are discussing today, you want to protect your assets. Look for somebody like Reed that's board certified. Look for somebody that's been practicing for a number of years and just hasn't jumped into it. And look for somebody that's going to be around for the long run. If a bankruptcy is done right, you shouldn't have any issues moving forward. But if issues do come up, you want to make sure your attorney is there, you're comfortable with your attorney and your attorney's staff, and that they'll be able to help you going forward. So do a little bit of due diligence. Make sure the attorney that you're using has the expertise and the experience to help you through a very difficult time in your life. Reed, bankruptcy is a very traumatic time for a lot of individuals. As you spoke to earlier, people come in and they're really hurting, and it's an opportunity to minister to them and help them get on with their lives. but we've got to do what we do properly. Reed, you may know more about this than I do, but I've heard of special types of trusts for firearms to protect firearms, both in bankruptcy and for other purposes. So, is it possible for somebody to put their firearms into a trust to protect them for their children, grandchildren, future family members?
Yeah, sure. Gun trusts are very popular in Texas. I mean, they can have a lot of great benefits, to avoid probate and protect those assets for your beneficiaries, protect those from predators. So as a general rule of thumb, you still have to transfer the property. So whether you're transferring it to a family member, or you're transferring it to a trust, the rules we talked about still apply. So if you're transferring right before filing for bankruptcy into a trust and you're not getting fair market value for it and so forth, it's going to be a preferential transfer. But if you do it far enough in advance of filing the bankruptcy, maybe before you're insolvent, and you set up the trust correctly, where it's it's a spendthrift trust and it's not basically you just setting up the trust and you're the beneficiary, then most likely those types of trusts in general would be able to pass the property through the bankruptcy, and it would still be protected and safe for your future beneficiaries.
What would be some of the other uses or benefits of a gun trust, Reed? Why are they used by gun owners in Texas and elsewhere?
There's a lot of different rules regarding the exactly like what kinds of weapons you can have and how much you can have. And sometimes the gun trusts allow you to own certain types of firearms and accessories that you would not be able to own if you're just doing it individually. There's the issues that also like talked about with asset protection. If you're looking to avoid having the gun seized potentially by a creditor or being attached. And also there's the advantage of passing those down to the next generation without having to go through probate and have those costly expenses and things associated with that.
Well, we have attorneys here at the Bond and Bodas law offices that work with gun trusts and helping set them up. And I know Reed's firm does also in Texas. So if it's something that's of interest to you to make sure that you protect firearms, again, you want to do this well before bankruptcy becomes necessary. Just like with anything else, transferring property immediately, even into a trust immediately before filing bankruptcy, can be dangerous and is not necessarily going to protect the firearm. The term Reed used, spendthrift, is again a legal term that says that when the property is put into the trust, the grantor, the person putting the property in, and the beneficiary, the person that has the benefit of the trust, really don't have immediate control anymore over that firearm. So it's protected from creditors. Specifically, the beneficiary, I guess, would be the individual in most cases, Reed.
Yeah.
We're seeing those become more and more popular throughout the states we practice in, and certainly something somebody should consider if they want to make sure their firearms are protected, not only for themselves, but for children, grandchildren, etc.
Yeah, if anybody's watching this, whether they're in financial difficulty or not, I mean, the stuff we're talking about here, it's good to get educated on what is asset protection, what isn't, what kind of property that you own, ways to protect that for the next generation or yourself. So it's good to know these things. I mean, I know from my personal experience, I'm sure you're probably the same, doing this every day for a living. Like every time if I acquire anything, I'm thinking like, what would happen if I have to file for bankruptcy?
Right.
Because would it be protected? And so it's good to think of those things way far in advance of actually having some type of financial hardship.
Which is why, and I continue to harp on it, and I've said it a couple of times during this presentation, but Reed, we both know it's just so important for individuals that think they may be getting into financial problems to talk to a qualified attorney just as soon as possible. We've done a number of Facebook Live episodes, and we've heard stories of people just making very poor decisions, like taking all of their money out of a 401k or retirement plan to use to try to deal with their debt. And people listen, while money is in a qualified retirement plan or an IRA, it is safe. It's protected from your creditors. Don't take that money out without consulting with a qualified attorney like Reed in advance. And there are so many things that you can do that may or may not be wise leading up to a bankruptcy filing. We offer free initial consultations, especially now during COVID. We'll do them virtually. We'll do them safely from comfort of your home or office. And Reed, I imagine things are the same in Texas. But
yeah, it's great.
We can do a bankruptcy from start to finish without leaving your home, really.
Exactly. Same here. And then also all the activities after the bankruptcy are required can also be done virtually. It's really, it's a horrible situation that we're in right now with the COVID situation. But, specifically when you talk about bankruptcy, it's so hard to reach out and ask for help because, a lot of people feel shameful. They feel that it's their fault that they're in this situation. And then nobody really wants to go and sit in the lobby with other people being like, oh, they're here to file for bankruptcy. So the luxury of being able to just be safe and secure in your home where nobody knows what's going on and you can ask all your questions and share all those things that you're afraid to share virtually and privately. That's a real added bonus that we've got from these times.
It really is. And, so many folks are nervous about going to a court hearing. Even the court hearings are being handled virtually now. You're not in a crowded courtroom. You're not having to go through security. All of that is handled virtually. So
yeah, because like having to pay for parking, trying to find the location, taking off of work. It's really very convenient right now to file bankruptcy if you think that you're going to be filing soon. You should take advantage of it now.
And as Reed said, good people have money problems. Folks, we understand. I've been doing this for over 30 years now. And one of the reasons I started my own practice years ago is because I didn't want to represent somebody that I didn't want to represent. People that come into my office, the vast majority of them are good, hardworking problem that just something bad's happened to them. It may have been a health problem. It may have been an injury. It may have been a job loss. Maybe they tried to start a business and the business didn't work. And right now, it's COVID. It's people are losing or have lost jobs. They're losing income. Small business owners are hurting. But we're here to help you if you need help, and there are options available. Please just know that there are options available. Folks, if the issues we are discussing today, protecting guns, gun ownership, in anticipation of bankruptcy are important to you or somebody you may know, these Facebook Live episodes that we are doing are recorded and they are available on our firm's Facebook page. And imagine this one will be available on Reed's firm's Facebook page. So if you know somebody that you think may have an interest in protecting firearms, please refer them back to our Facebook page. The Bond & Bodas Law Office's Facebook page, Allman Law has a Facebook page, and we've done a series of interesting episodes. Last week, we featured a mutual friend of ours, board-certified attorney Eric Clark out of Los Angeles, and Eric and I talked, Reed, about the debt consolidation and debt negotiation companies that advertise late night and sound like the next best thing and a way to avoid bankruptcy. We
they always say
perils.
And they always say, don't file for bankruptcy, call me.
Yeah. And they end up hurting your credit much more worse than bankruptcy ever would. Let's see. I have some questions coming in here. So Reed, this is more of a general question. I think we've touched on it, but perhaps you can emphasize, if I file bankruptcy, am I going to be forced to auction off or sell my guns?
No. When you file bankruptcy, either Chapter 7 or Chapter 13, you're not going to be selling anything. In a Chapter 7, if you have non-exempt property, which we've been discussing, the trustee may or may not take an interest in that property and try to sell it to pay something to your creditors. And in a Chapter 13, the trustee doesn't have the authority to take any of your stuff and sell it. They just require you to pay in whatever the value of that non-exempt property is to your creditor. So if you had $1,000 of non-exempt property over a 3 or 5 year plan, as long as you pay that $1,000 to equally be shared amongst your creditors, then you're going to be in good shape. So, and oftentimes, if it's small value, the trustee has to justify that there's a benefit to the estate by going through the time and expense of doing this. So I've often had people who've had $2,000-3,000, sometimes even more, where they file that's not exempt, and the trustee just abandons their interest. So,
sure.
It's a very jurisdiction specific kind of practice that you have to ask local attorneys.
And you need to know who the bankruptcy trustees are and how they function. I want to clarify, because I know it can scare people. Reed did say accurately that the Chapter 7 trustee does have the authority to sell assets you may have that are not exempt, that can't be protected. But if you've been upfront with your attorney is going to know that is a possibility before your bankruptcy is even filed, and going to be able to advise you as to how you can keep from having your guns sold by a Chapter 7 trustee. Furthermore, even if the Chapter 7 trustee does decide that he or she is going to sell your guns, usually the first person they're going to come to is going to be the person filing bankruptcy. I imagine it works the same way there, Reed, but if we go into a court hearing and the Chapter 7 trustee questions one of my clients and learns that there are guns that maybe can't be protected, and he knows that he has to sell those guns, he's going to call me and he's going to say, does your client want to buy those guns back, or does a family member want to buy them so that they don't go to third parties? Is that your experience also in Texas?
Oh, yes. We're able to work those kind of deals, in even some very interesting deals where we've actually been able to set clients up on payment plans and let them even pay back, over an extended period of time, the value of that non-exempt property. So there's lots of options available.
Yeah. It's just important, though, that your attorney knows. You don't want your attorney surprised.
No.
The way a Chapter 13 bankruptcy works, and re-jump in here, but the two primary types of bankruptcy available to individuals are Chapter 7, which most people think of as a straight bankruptcy, and Chapter 13, which is an individual reorganization. Technically, an individual sometimes can also file a Chapter 12, a farmer or fisherman bankruptcy, or Chapter 11, which is a larger reorganization. But in a Chapter 7, it's a quick process. It's called a liquidation process, but very seldom are any assets actually liquidated. Time process is over in 4 to 5 months. You get rid of most of your debt and you get on with your life. But if you have assets, guns in particular for today's episode, that you can't protect through a straight bankruptcy, through a reorganization bankruptcy, a Chapter 13, you pay as much to your creditors as they might have received if your guns were liquidated. And you can do it over a 3 to 5 year period of time without any interest or late charges or penalties, and protect those assets. As we talked earlier, in Texas, there are some very generous exemptions, which would often protect all of your guns, all of your firearms. In Alabama, Mississippi, or Tennessee, although that may not be the case, we're still going to take every step necessary to protect your firearms.
It's something in Chapter 13 that a lot of people aren't aware of, is just because you owe somebody doesn't mean that they're going to get paid. Because they amended the rules a couple of years ago, and if you list a creditor and send them notice of your Chapter 13, they have a very short amount of time to fill out a proof of claim and file. And I can't tell you the amount of times I've filed a case for somebody who has $100,000 worth of unsecured debt, and we get $15,000 worth of claims come in. So that other, 85,000 is just gone, like it would be in a Chapter 7. So even if you have non-exempt property and you file a 13, you may still not even have to pay it back to the creditors based on who shows up to participate.
It's interesting you say that because Eric Clark, our friend, made the same exact point last week. I think he made the reference to bankruptcy sweepstakes or something like that, but it's true. So when we file your bankruptcy petition, we do a good job of making sure we list all of the creditors you've told us about and other creditors that may be on your credit report, and we make sure they're notified properly of your bankruptcy proceeding. But they have a limited amount of time to file a sworn claim with the bankruptcy court. If they don't do it, they don't get paid. Furthermore, if they don't do it right and you have a good attorney like Reed or one of the attorneys here with the Bond and Botus law offices, will object to that claim and they won't be paid through your bankruptcy. So you're right. Not all creditors get paid, Reed. And again, the excellent point made by you as a board certified attorney and Eric Clark as a board certified bankruptcy is and that if they do not file their claim or file it properly, that they don't get paid through your bankruptcy. Well, all right, this question that came, Reed, I'll let you speak to this since you're from the great state of Texas. If I resist, can my guns be seized or taken from
me? Okay, so you file the bankruptcy case. Hopefully there's been a discussion about whether these are exempt or not. And you file the chapters, file the Chapter 7 and they're not exempt and the trustee is asking for them. You can resist, give it to them or refuse to, but you're dealing with an officer of the court who has authority to request relief from the judge. One of those things, it might be to deny your bankruptcy discharge so that you're never able to discharge that debt again, ever. They can do a motion to compel you to turn it over. And if you don't turn it over, they can send the U.S. constables or the U.S. Marshals and arrest you and get it. So, yeah, hopefully it never gets to that point, but it's possible.
Well, all the more reason, again, to have a good attorney so that you're not surprised by those type issues. It's much easier to do a bankruptcy and much less expensive to do a bankruptcy properly in the first place than try to fix a bankruptcy that's done improperly or to be surprised.
Yeah.
The question asks, can I resist a court order? Folks, money problems are one thing. Criminal problems are a lot worse. So make sure you're guided through the bankruptcy process properly and with good advice. Reed, I have a question here from Richard. He says, if I'm an avid collector and I have a significant amount of ammo, does it have to be listed in my bankruptcy schedules?
That's a really good question. And a lot of people, who have lots of weapons have lots of ammo, and it can be, there's various kinds that can be expensive. So yes, it's an asset. You still have to list it. And it's going to go back to, it's not a firearm. So we would have to, look at other provisions to potentially list that in your bankruptcy schedule. But it definitely needs to be disclosed, listed in the bankruptcy, and dealt with prior to filing. So that's a good question.
Absolutely. And there are other, hunting accessories that you may have also. You've got to list all of your property and disclose it to your attorney so that your attorney can advise you properly to make sure you protect your property moving forward. Reed, I've touched upon the questions I had. Is there anything that you think is important to add to advise gun owners that might be having financial problems that might need to seek bankruptcy protection going forward?
Right. Well, I would say that all this, a lot of people can kind of get lost in the details of everything we're talking about. And you really just had to kind of keep it in perspective, that if you believe us when we say that most people who file bankruptcy are able to keep everything, and there's absolutely no risk to talking to somebody. And if you are speaking with a competent bankruptcy attorney, you're going to know what's going to happen with your property long before you ever file. Then there's no harm in getting more information. And if hypothetically you do have some non-exempt property, you need to consider, like, if somebody walked up to you on the street and said, I'll wipe out $100,000 of your medical debt, credit card debt, and I just want you to turn over that extra pistol you have that's worth $500, would you do it? I mean, a lot of people would do that in a heartbeat. So keep it in perspective about what you're getting rid of, and what you're getting from the bankruptcy is compared to what potentially you may have to turn over in the 1% of cases where that actually shows up.
It's very difficult to get to a bankruptcy attorney's office to make the decision that you need to seek advice. But I can tell you from having done this for 30 years, and I'm sure Reed will back this up, once you make the decision to seek protection, the relief can be so immense. The burden off of your shoulders, the fresh start that the bankruptcy laws allow can be significant. Reed, I know we've saved marriages over the years. People come in, and husbands and wife, the financial issues, they're bickering back and forth, and the anxiety. We're all facing a lot of that today. But bankruptcy can be really, it can get rid of that anxiety, that stress, and repair relationships, help people become better spouses, better parents, better people.
Because, we're just talking about stuff. Stuff comes and goes. And so there's no reason to lose relationships. I've had some very gut-wrenching meetings with clients. They've shared things with me, even potentially suicidal, concerns. And it's just not worth it. And having financial freedom and being debt-free, I think, is way more valuable than a firearm. So, just keep that in mind.
Yeah, I'm just going to throw in one more thing to that point there. I want to underscore the fact that bankruptcy doesn't mean that you can't pay your creditors back. If it's a pride thing, and you want to do your best to pay people back, I'll provide you, if you reap the success of bankruptcy, of the fresh start, and you become very successful, you can always pay folks back. You're just not required to by law. You're not required. The phone calls are going to stop. The collection activity is going to stop. You can get on with your life. And that's what we want to help you with. We want to help you get on with your life if you're facing serious financial problems. In closing, I'm Brad Bodis with the Bond & Bodis Law Offices. My guest today, Reed Allman, is with Allman Law. Allman Law helps people with money problems in the Dallas-Fort Worth area, one of the best, largest consumer bankruptcy practices in Texas. At the Bond & Bodis Law Offices, we help people throughout Alabama, throughout Mississippi, and in the Knoxville area in Tennessee. If you're having money problems, if you think you're going to have money problems, or if you know somebody that is dealing with the anxiety that financial problems can bring, please encourage them to reach out to one of our offices. We're offering absolutely free, no commitment, no obligation consultations with an experienced attorney who will help you address your situation so you know the proper steps to make going forward. You can reach our offices by calling the numbers that have been displayed on the screen here today, or by going to our websites where you can gather more information and complete a form and request a consultation. But we have folks answering the phones at both of our firms that will be glad to talk to you, assess your situation, and make sure you have a consultation scheduled with a qualified attorney just as quickly as possible, so that you can get these concerns off of your shoulders and get on with your life. We want to help you, and thank you, Reed. I know you feel the same. You expressed it so greatly at the beginning of this episode. We're about helping people, making them feel better, and uh, helping them obtain the fresh start that bankruptcy can provide. Feel free to reach out to any of our offices. If you know somebody that could benefit by what we've discussed here today, please refer them to our Facebook pages, where recordings of this and our previous Facebook Live episodes are available. But until next Wednesday at 1 o'clock p.m. Central Standard Time, I want to thank all of you, and Reed Allman with Allman Law, thank you so much for helping us out today. Have a
Thanks
great
for having me,
day.
Brad.
God bless all of you, and we'll see you next week.